It was derived by Stephen Owen when he was the ombudsman. It came out of a scandal involving the old social credit government. It's a system that by and large I think works quite well because it does establish the political independence of the special prosecutor. Having said that, this particular case I think raises serious questions about how the special prosecutor and the Crown have handled themselves in this case, because the amount of disclosure documents that suddenly 4 years later another 100,000 pages appear in a box buried in a closet.
That might not be his fault. That might be the police, right?
Well, it's
the
either one.
either
one.
Well, at one point the judge found that not all the police notes had been disclosed, and she ordered every single officer to look at every scrap of paper they had in their possession and make sure it had been disclosed. And I think it gave the special prosecutor a huge headache because they thought it was all disclosed.
There was a massive evidence room over here on the island that the defense lawyers got to go in and double-check the disclosure. Neil, is one of the problems here that there was this drug case going on, and there was a whole lot of documents in that, and then this second case begins.
Exactly.
And I mean, there may be honest mistakes in this where stuff that overlap didn't occur.
I'm sure there was, and stuff where there's innocent people involved in wiretaps, and they have to wade through the stuff. I mean, you know how many calls that Basi and Virk were making. I mean, and it was going right into the minister's offices where they were wiretapping, right?
But the same phone is taking calls from constituents. There's one of these calls that the premier is on, right?
Yes.
But he's not. It's not that he's suspected of doing anything wrong. He's on a wiretap.
But back to your central point, there's no way for anybody to step into this and tell the special prosecutor to do anything different, and nor should there be a way. I mean, Bill Berdino is independent to call his own shots here.
We will take a brief break on Voice of BC and be back with, I guess, some more of the loose ends in this case. The question, among other things, we're going to talk about the possibility this whole case may collapse. Stay with us on Voice of BC.
There are lots of aspects and lots of questions that Mr. Campbell has been asked that have nothing to do with the matter before the courts that he's gotten away with by saying, oh, well, the case hasn't been decided. Politically smart, so far. I don't see calls for Mr. Campbell to come clean or resign over this case. So if success is the measure of the virtues of a strategy, this is a good strategy.
Wetlands provide rebroadcasts Saturday mornings at 10 and Sundays at 2 p.m. North Vancouver Island residents can watch Fridays at 4 p.m. or Sunday afternoons at 2. For all other Shaw systems across BC, Voice of BC rebroadcasts Sundays at 2 p.m.
It's easy to any democratic process, and it is totally improper, those principles.
So there's the Attorney General of British Columbia, Wally Opal, giving an answer that he gave about 150 times in the legislature last year, and I think the count is up already to 50 this year. Is this a legitimate response to all questions in this case, Keith?
Well, on the one hand, I can certainly see, if you flip it around, if the Attorney General were to start making all sorts of strange comments about something that is in court, that opens up a whole different can of worms. I mean, pretend it's not BC Rail, pretend it's another case that isn't politically charged. That's improper conduct by the Attorney General. Having said that, some of the things that came up on the dirty tricks allegations in court, it wasn't necessarily evidence yet. It was technically in front of a judge. Gordon Campbell refuses to even say whether anybody ever phoned a hotline radio show pretending to be someone other than he is on the direction of government. He just won't discuss that whatsoever, which I'm not so sure they have a complete out on something like that.
Another issue that they've declined to answer questions on is what is the government policy regarding acceptance of freebies, of free trips? Neil Hall, why is that question relevant in this case?
One of the allegations in this case is that the two political aides took their wives and themselves and went to Denver, Colorado, the head office of Omnitrax, and went with the executives of Omnitrax to a Denver Broncos game. Accepted free tickets. That's the allegation. The defense wanted to know how many people accept Canucks tickets or go to events or the opera and on behalf of government, and whether this was strictly one of those trips. I mean,
Yeah.
Did somebody know they were going? Did they...
Again, as a normal operation of government, which is the central defense.
And the opposition has tried to raise this issue in a number of ways, but they do not get up in court and say, Mr. Attorney General, do you think these guys are guilty? That is not the kind of thing they're asking. A lot of what they're asking is this collateral stuff. Well, there's been an allegation in the trial this happened. What is the government's general policy on taking freebies? And they don't get answers. What they get is the Attorney General getting up and saying that. Disclosure is, we've referred to it a bunch of times, as one of the central issues in this case, and now we're going to deal with a couple of the disclosure issues and then the question of whether or not this will ever get to trial. Here, raising the disclosure issue is Bill Tillman again. Here's Bill.
One of the key concerns in the BC legislature case is how the government handles disclosure of confidential government documents. It originally asserted both cabinet and solicitor-client privilege over a number of documents. Cabinet privilege has now been waived, but solicitor-client privilege has not, on as many as 100 documents related to the sale of BC Rail. If these documents are not disclosed, the defense may have a strong case to suggest that it is avoiding, the government is avoiding giving them evidence that would actually lead to the exoneration of the accused. On the other hand, it could be extremely embarrassing for the government to release BC Rail sale details that might put the government in a bad light. Ultimately, Justice Bennett will have to decide, but it could be appealed to a higher level of court.
So you've got 100, he says 100, we've heard 36, we've heard all kinds of numbers of documents the government is arguing so far can't be disclosed to the defense or limited disclosure, Neil Hall, because solicitor-client privilege. Essentially, if I get a letter from my lawyer, that's covered by solicitor-client privilege.
Yes, and advice to the government, legal advice, they're saying should be solicitor-client privilege. It shouldn't be shared with the public. It should be confidential.
But Keith Baldry, there's a suggestion in this case, and only a suggestion, that some of these documents aren't letters from lawyers at all, and they aren't legal advice.
Well, no, and a lot of these emails that are the subject of a lot of these documents are CC'd to a lot of other people as well. It's
They're
not
emails
just
to the accused.
My understanding, to Bob Virk in particular, he received a lot of emails in his capacity as Minister of Aid to the Minister of Transportation. He was CC'd on a lot of emails. A lot of it obviously had to do with the sale of BC Rail, but it wasn't all just one lawyer providing advice on a legal issue. There was all sorts of things tied to that transaction. So it's still a murky area, and the government is still arguing, no, it's solicitor-client privilege. The judges identified three that I think that are really relevant to this case, and one of them's extremely relevant, which goes to what she says is innocence at stake, and
she
could establish
makes the final
innocence.
call, right? The government doesn't make the final call. She does.
She can look at all those government documents and decide whether they are relevant to the case, and she has, and has.
But she hasn't made the final ruling on this yet. And
well, we might not have all the documents yet. That's the problem.
Yes.
Okay.
Have we got there yet?
Second issue on disclosure, different aspect of it, and asking the question here is the opposition critic. He's been in court a fair amount on this as well. This is Leonard Krogh, who is the opposition critic for Justice Matters, and with a question on this, Leonard Krogh.
The troubling aspect of this case is how long it took the Crown to make disclosure. Issues around solicitor-client privilege, cabinet confidentiality, parliamentary privilege. The fact is the judge, Justice Bennett in this case, had to make an unprecedented, all-encompassing order that shouldn't have been necessary.
We referenced this already, and last February the judge says in court this thing should go ahead, it should be aired in open court, and is it last June that she came crashing down? Yeah.
Yes, she was made quite a scathing comment. She was just shocked that all the disclosure hadn't, because they produced notes from an officer there, or some details that they actually heard one witness who came and